Greetings and salutations. Welcome to another episode of the Legal Beagle podcast. Today we're talking with David Tulis from Eastern Tennessee. Seems to be pretty good acquainted with John Gentry, who we just had on. David and I today get into first the topic of COVID with one of his lawsuits. Then we go into some mandatory insurance in the state of Tennessee that they're trying to pass or did pass, requiring almost everyone to get SR22 insurance, and saying that they had some loopholes, but in fact they don't, except for the rich. And so he's fighting on behalf of the poor in this particular instance, as well as then we get into some vampire lenders. Been a member of the press and still continues to be, and has been in radio, as you'll be able to tell from his voice. We had a lot of technical difficulties getting this together, getting him the sound proper on his side and this side. And so he eventually had to switch to his phone, which loses signal every now and then. So please, it sounded fine. Like I could hear it a little bit distorted, but it didn't sound that it was terrible. I've listened to it here and I think it's okay. I'm sure you're gonna let me know if it's not, but it seemed to be loud enough and clear enough. He enunciated everything very well, so it was easy to understand him. So hopefully that won't affect your end too much. But without further ado, I'm going to introduce you to David. Here we go. Welcome, David. Thank you for being here.
Well, thank you so much, Gary, for having me. My name is David Tulis. I'm an investigative reporter in Chattanooga. I've been 12 years in the radio business, 24 years in the newspaper editing business. I was a copy editor at the Times Free Press in Chattanooga. And my work is in journalism, and it's very much outside the mainstream of the legacy press. Radio, of course, is considered legacy press. And all radio is effectively bought and paid for by people who run the advertising. And if you object to the establishment perspective on law or liberty or Constitution or God himself, you are going to be on the outside. So I've been on that outside sector most of my professional life after having left the newspaper business. And in fact, I've been so much, I must say, oppressed by the algorithms and just sort of the establishment framework of thinking that it's impossible to be in the radio business any longer for now. So I've closed off my radio platform, and I'm just I'm running what people deserve. It happens to be the best of rock hits here in Chattanooga, and that's what they deserve. They don't deserve anything better than that. They don't deserve me on the air. And so I say, well, that's okay. I'm not offended. I just accept that the market is, you might say, a sign of God's providence, that they don't deserve accurate and true reporting and contrarian analysis of the kind that if you read the scriptures or you read law or the Constitution, you will offer. So that's what I've been offering, and continue to do that as a member of the press. And also what I've found myself doing is in covering people's legal distress, usually small offenses. I find that they are greatly blessed by the coverage because they read my analysis and they suddenly understand their situation vis-a-vis the statute here in Tennessee. So my coverage is insightful to the object, or should I say the subject of the coverage, and many of whom have liberated themselves from oppressive, ultra-virus police harms and judicial harms that if they listen to my dumb questions, they figure out where they are. So that's kind of my coverage. It's about court cases and judicial improprieties and the like. Now, I'm the journalist who sued the governor of Tennessee. His name is Bill Lee, a Republican, pretendedly a Christian man, but who declared a state of martial law in 2020, and I was in court 878 days with him, Gary, insisting that he obey the statute. And my protocol is one that I learned really at the hands of I'd say a true legal master. His name is Hal Anthony. He's in Oregon. He is the legal researcher at a mining district in a four-state mining district in Oregon. and he runs a podcast on Sundays called the name escapes me, but it's called Behind the Woodshed. It's a podcast at reallibertymedia.com, and his name is Hal Anthony. A real treasure as far as legal knowledge, deeply legally read, especially in property law, land law. And so I've gotten a lot of from him. So in that case, what I did in my suit was determine where the administration had violated the statute. And all of our state statutes come from the same origin. That would be from the early 1900s, and where there's certain authorities given in the interest of public health to departments of the executive branch. And we found that he had just simply ignored the epidemics statute, Gary, that required him to do 6 things. And one of them was to make a determination of the agent of contagion. And we found by inquiry, as a press member inquiries, that he had not made any such determination. So how can he attempt to mitigate COVID-19, the so-called COVID virus, without determining that was it? So there had been no isolate ever. There still has not been an isolate of COVID. All the material
or any virus, or any virus.
Well, maybe any virus, right? And so what they have are DNA data from mining DNA, and that's really all they have, and that's how they manipulated the CV19 bacteria, if you will, to generate the little that year's version of the flu. So we found that he was violating black letter law, and of course, in so doing, when you have like in the scriptures, when you have one sin, it begets many other sins, one to cover the other. So we found that in violating the statute at 685104 in the Tennessee Code, he was also breaching fundamental due process rights, the prohibition in Tennessee on martial law. So he had martial law, and he had pretended use of judicial power upon all people all at once. And of course, American jurisprudence does not operate in masses, right? There are no mass searches, there are no mass arrests, there are no such thing as mass trials. You have a right to a magistrate hearing on arrest personally, right? The law operates personally.
Well, in theory.
And that's right, in theory. But in the law, for example, in the Tennessee health law, the tuberculosis statute has a whole section on how a tuberculosis case is determined and how you have a right to be prosecuted civilly in sessions court. That's our county level court in Tennessee. You have a right to be prosecuted there, and to be forced to show up, and you have a right to question witnesses and establish as a matter of law by preponderance of the evidence that you are sick. And if the judge is convinced by the health department expert or witness or person who has the data that you're sick, well, then you lose, right? And then you're confined to quarantine, one person at a time. So the system operates personally and individually, and that's the best in the biblical model, that harms by sins and public crimes are handled individually, one by one. And so it's these are our biblical antecedents in law, you could say, and that was what should have happened for the 2020 flu, but it didn't. And so that was my second big case, if you will. Of course, there was a.
And was that in state court or federal court?
Well, I made the mistake of filing in state court, somewhat wary and maybe a little bit afraid of going into federal, and but that was really a mistake, because the judge who had my mandamus, it was petition for writ of mandamus and equity. Of course, mandamus is a remedy for compelling an official to do a non-optional duty, a ministerial duty, duty that he has no option but to do. One more point about mandamus. A mandamus action compels the official to make a choice of doing A, B, or C. Now, mandamus won't compel him to do any one of those, but it will compel him to make the act in which his discretion might be A, B, or C. So I was demanding a mandamus to compel the governor to make a determination of the agent, and was blocked for 204 days in the Chancery Court, which is the court of equity, the court for probate and estates and things like that, and cases where there are not money damages demanded, but a relief, relief and justice to be restored. Equity is a very powerful, a very wonderful jurisdiction. I love equity, and we have in Tennessee a famous expert, Robert Gibson, whose 2-volume set I had a copy of. In fact, I've read all the relevant parts before going into this case. So, and a book that has many wonderful maxims of law. So that jurisdiction, Chancery. The book is called Gibson's Suits in Chancery. It's called Gibson's Suits in Chancery if you're in Tennessee. Was my guide, and so a mandamus action when there's an emergency like this is like a petition for injunction. It has immediate hearing. I filed my case on Friday, and the judge should have commanded the governor to be in Chattanooga for a show cause hearing, let's say Tuesday or Wednesday. That's how fast an equity action like that with continuing emergency harm is supposed to operate. But she sat on this case 200 days and clearly was following policy and not the forthwith command in the mandamus statute.
200 days, David. That's we haven't even gotten to the motions to dismiss in Louisiana in 200 days. I got a case in the Middle District, 400 days. The judge has sat on the motions to dismiss.
Well, a motion to dismiss doesn't deserve emergency time. That's not emergency time unless you have an emergency case. Here, mandamus has in view equity, but it has also in view immediate harm to the law itself. And we have we're in a state of emergency, a declared emergency, which broke in Tennessee on March 12th. The reason I got nowhere with the county judge and the Court of Appeals or SCO-10, the Tennessee Supreme Court, is that they had sided with the governor in the overthrow, and effectively it was a coup. And because the judges in the next day after the declared state of emergency in Tennessee, they had their own executive decree shutting down the courts. They pretended to have them open, but they were not open, and so they were effectively compromised. And believe me, when I got defeated in the Court of Appeals for no standing, right? I had no standing. I wasn't injured. SCO-10 refused to hear the case because I demanded recusal, first of 2 of the justices for cause. One of them I was suing in federal court, or about to sue in federal court, for having me arrested in a separate issue. And then when I demanded recusal of all of them, they declined to hear the case, but they said in a 2-page ruling, this is refusing to hear the case. They said this is a non-trivial issue. In other words, it was a real issue, but they were just exercising their prowess and discretion to not hear it. So Tennessee courts were a mistake.
Yeah.
Don't plan to make that mistake again.
Well, I tell you, the court case I was saying 400 days about was included TROs and injunction relief about the pandemic, and again, we're still sitting there waiting on the first ruling in the motion to dismiss. But the federals can be just as bad as the state for sure. But and I would have thought that maybe, well, since it's a writ of mandamus, it probably didn't matter. But if it would have been for any damages, the 11th Amendment would have barred you from going to the feds or something, so.
Well, there were federal issues. Perhaps the one that comes to mind immediately, Gary, is the right to a Republican form of government. And when you have a state of emergency, you have a unitary state. You have all parties serving the state, the legislature mute, the judicial branch not acting as the sentinel to stop the breach. And getting back to the way Hal Anthony and I work this case is we fired, there are all kinds of, in the train, you've seen the P-40, the P-51 strafing videos of German trains and barracks and so on.
Sure.
When you have a breach of statute like that and you're determined to follow the herd, you have many boxcars full of wrongs, right? Constitutional wrongs. And so we were firing our tracers at the locomotive, and that was the breach of the statute. And to do that, to do that, we realized here are 105 words, I think it was, or 102 words in the relevant statute with 6 steps. And so my practice in doing that was just to study, you might say, to write out on paper in large font, 24-point font, write the whole statute out, and every word means something. And you just have to, and it's easy, Gary, for me just to read something and think I get it, and I don't. And so slow reading in large type, printed, not just on the screen, but printed out, annotated. You start there. And that's what we did. We just said, what does he have to do when there's an epidemic? Pandemic doesn't exist in American law. Pandemic is cross jurisdictions. We have states in authority. They have this authority by statute. And there is no such thing as a pandemic. There are epidemics, and they have to be, in our law, determined locally. Every county has to make a determination locally.
Yeah.
And so that was not done. And so there was no reporting of local county health departments giving a report to Nashville what was happening, what determination these local doctors had made. They had not done that. So the governor acted on a vacuum. He had no basis. In other words, no lawful basis for an emergency. And so in the train behind the caboose that in our mind, we had exploded with our armor piercing, were, martial law. That was one of the main ones, was that you have a military type claim that was pretendedly aimed at everybody. But the martial law was only sort of presumed because executive orders control executive branch. If you read very carefully, these are all legally correctly written, I would say. The order is upon the people and persons. And while it might sound like it's applying to you as a citizen, it was really applying to all persons subject to the governor through executive orders, which again is all the bureaucracy and all the exceptions that are made in a state of emergency to speed things up, to allow out-of-town health workers into the state to serve if need be without proper permitting, that kind of thing.
Yeah.
And so that's what we learned there. And so I think the case I really want to talk about with you is mandatory insurance.
Yes.
And that, I think the best use I can have for your listeners who already have a full plate, they are all stacked. Okay. And I get that. But if you have someone who are under a financial responsibility law charge, it really bears looking into as to whether or not you are a financial responsibility state, as we are, or a mandatory insurance state, which some states apparently are. About 4 minutes to explain how financial responsibility works and what the theory behind it is. And then you can ask yourself, is that kind of language in our statute? Because I bet it is. And I bet that the IICMBA telling me that 49 states have mandatory insurance is wrong.
Yeah.
And it could be that the other states also are running a scam. Now, this is important. I know you're not going to get to this unless you're in this case, but tuck it in the back of your mind, because you may have a friend who's charged with failure to financial responsibility. Today in Chattanooga, there were 8 revoked license, suspended license cases, and there were 4 or 5 insurance cases. One prosecution of a man in the jail here in Chattanooga, the sole charge was financial responsibility. So they are prosecuting people. And here there have been, in a recent 5-year period, 408,820 some convictions on this case, and they're all poor people. Poor people generally don't have insurance, and so the strip mining of motorists and having them as sort of fuel or lubrication for the judicial process. 408,800 people convicted in this 5-year period. Again, those, you have to remember, these are not white collar people like you and people of means like you, or people who are bow ties, right? They're poor people with bad grammar, bad teeth, bad breath, old cars, no means, no padding. They're barely making their bills, and now they have a criminal case because their tag has been revoked because they don't have insurance. So insurance is a raping of the poor. and I'm in court in the Commissioner of Revenue's pseudo court administrative realm, demanding an end to the Tennessee program. All right, here's the outline of how financial responsibility works. And if you see this outline in your statute, then you know that probably in a recent update, maybe as late as 2018 or 2016 or 15, there's been a revision of the statute allowing your state to be converted into a mandatory insurance state. So these are what I'll tell you now is kind of the signals to look for on financial responsibility. Financial responsibility is a paternalistic jurisprudence that came about in many states just after World War II. Ours was 1948. And what it does, it has the Commissioner of Safety guarantee through the licensing power that he has, and also the registering power into commerce, he has a weapon upon those who are financially irresponsible. These are people, your financial responsibility operates after an accident. No one understands this, but responsibility is after accident, showing that you will make good. And so you have, your statute has in the beginning of it a provision on what has to happen to trigger the operation of the law. The law operates after a qualifying crash. In Tennessee, it's $1,500 or injury or death. That's a qualifying crash, and that invokes the authority of the statute upon you. The rule is you have to give a report to the Commissioner of Safety or the equivalent in your state within a very short time, 20 days. He wants to know the damages and so on, and maybe who's responsible. He makes a determination administratively of who's responsible, and then he says, okay, well, I'm requiring you to put money up, or I'm requiring you to do one of the 4 tests. In our state, it's 4 tests. One is show proof of insurance. Okay, don't have insurance? That's okay. Well, number 2 is you can post a bond. You can buy a surety bond from your insurance company. Let's say it's a $25,000 crash. You buy a surety bond that the bond issuer guarantees that you will pay the damages if you're shown responsible. And he has, let's say, security, let's say of a house or a car, or maybe you give him some gold or write him a check. Okay, so he's got a $25,000 surety bond. You get the certificate of that bond, show the Commissioner of Safety that you are secure. You're showing financial security. Why? Because you are responsible for the accident, and that shows that you have financial responsibility by the security of financial security. Okay, so another option is you send the Commissioner of Safety $20,000. He says that based on the estimates, that's the damage. You're responsible, and so you're going to pay your own costs from this and the cost of the party you injured. $20,000. Send me the check. So he then pays the damages, the clinic, the repair shop, and the fourth option. Let's see. That's the fourth option is that the parties who are not insured, because they don't have to have insurance, they say, Commissioner, we're certifying by affidavit that we are settling this ourselves. We're not insured, but we settle it ourselves. So those are the four ways of showing financial responsibility upon a particular crash. Now, security is a standalone concept. If you're secure, you're rich. Okay, you have means of paying. In these accidents, the Commissioner and the state wants to make sure that the injured party, the victim, has you to secure his expenses. So again, there's a moral purpose, and you are responsible by doing any one of those 4 steps and then making good on your part in the damages. Again, let's assume it's you. You're making good on your part, showing responsibility. You have fulfilled your duty in the statute. In a mandatory insurance state, there is a precondition to the use of the car that is imposed upon the general public. I don't know that that will be constitutional in Tennessee. The General Assembly rejected a mandatory insurance law in '99, which would have been a disaster, because it simply tacked on one more provision on a 3-part statute. without deleting all the redundancies of the current law that we have. And so that's the outline of responsibility. Now, what's happened in Tennessee, it may be in your state, and you'll have to you just read the statute to find out, is that the Revenue Department used a technical amendment to the law that was technical in that it created a surveillance system. And probably in all the states, this would have been about 2014 or 15. We in 15 studied. Well, the General Assembly was told you can have this new surveillance system, data mining, to create a system already started elsewhere. And so the General Assembly passed a law in 15, and in 16 it said you Revenue develop what I call the Eye of Sauron. And that Eye of Sauron will surveil those people who have shown themselves financially irresponsible under the financial responsibility law. People who failed to make good, who didn't pay, people who have maybe under a DUI judgment or a limitation on their license, on a suspended license, or who had a court judgment in a crash against them. Those are all called high risk. In Tennessee, we've got 6.34 million registered vehicles. There are about 3,000 high-risk people in Tennessee. It's actually a smaller number than that. So Sauron was created, it's called EIVIS, Electronic Insurance Verification System. That allows Revenue to surveil all the data of who? Of insurance companies. So the insurance companies were told, join our club. The special club was made of insurance companies, 350 of them all together.
And they have a lot of data.
That's a lot of data. 350 companies that have motor vehicle policies. They're part of this nonprofit group. And so they all follow the IICMVA standards for data mining and data presentation. And surveillance of, again, it's a fly swatter's worth of work of these 3,000 people, because they have to have insurance. In our state, the statute says they have to have insurance because they're high risk, and that means that they buy more expensive policies, and they have what are called SR22 insurance certificates. That's a proof of insurance that you have in your car, which is a special certificate. And again, 3,000 people are subject to the statute. But
and the SR22 insurance is just a really high priced insurance because you're risk. You're a risky gamble. From one of the things you mentioned earlier, being in a wreck or DUI.
That's right.
Suspended license, right?
Well, here's let me just show you a picture. This right here is a picture of what happened. So here, this is the body of people who were subject before the Atwood Amendment went into effect. Atwood took effect January 1, 2017 in Tennessee, right here. So this body of people were those legally subject to surveillance because they were high risk. When surveillance took place, when EVIS went into effect on that date, January 1, midnight, this whole body here, suddenly all these people became subject. They became subject to a known legal duty, or so we're told in this case. So what happened was the statute that is a technical statute creating this mining system became operative upon the entirety of the 6.34 million registrants in Tennessee. And so the question is, how did these people become liable? Was there a change in the liability statute anywhere? And the answer is no. The answer is no. And here's another little picture that shows kind of what's at stake here. So you have inside the circle, you have the body of registered drivers, and you have the Eye of Sauron. Here's the Eye of Sauron right here.
Yeah.
That Eye of Sauron is supposed to look only at the small body of people, the 3,000. That's the actual target of Sauron. But what they've done in Revenue is redirect the eyeball. right? The eyeball is not supposed to be open all the way, Gary. It's supposed to be a pinhole.
Well, does this surprise you?
The pinhole is what they're supposed to look at so that they can see
And
these people here.
It sounds
this is lawful and proper. This over here is unlawful and improper. So Sauron is what we're trying to throw a javelin to that eyeball, Gary.
And do you think that the insurance companies lobbied for this?
Well, I looked at the donation stream for insurance companies into the political process. It was, I'm thinking, it was about $28 million a year. $28 million a year before this passed, and then it sank down to about 16 more recently. So payments by insurance companies to the political process has dropped off. And the statute required that Revenue Department, DOR, work with insurance companies to build this system. But in a deposition a week ago, the official who oversees this program said there was no cooperation with insurance companies, nor was there any cooperation with the Department of Revenue, with the Department of Safety to handle this. Now, safety, look at it this way, safety has a process that I'm going to show you a picture of how it runs. Safety is in charge of this program, and Revenue is operating a rogue program. Here's safety. Revenue is operating a program over it, okay? And its law, a technical law in Atwood, the one that took effect in 2017, doesn't touch this one. It runs completely separately, and I would say really in cross purposes. And that is because it has a different moral standard, a different liability standard upon the parties, the people, the registrants, subject to the law. Here, safety says you're not subject to the law until there's a qualifying accident. And we know that's true because in Tennessee, when you get a driver's license, Gary, you certify that you agree, that you understand about the financial responsibility law of 1977, and you agree to abide by it. Well, the reason you have that in there is because you're not subject to the law when you get the license. You're not subject until you have that first crash, which might be years later. But since you're a licensee, you agree to obey at a future time this statute. Okay, so we've got that law here. What I'm talking about, you agree to obey this law here, run by safety. Now, Revenue has this new law over here that started off in 2017, January 1, running with another moral dimension. And there, the moral dimension is, well, everybody's a scofflaw. Everybody's a high-risk driver. Everybody, and you're nodding, everybody's bad. Everybody's dangerous. Nobody should be on the road unless they're all effectively rich.
Yeah,
you have to have financial security at all times.
More power, more
and you have
control.
to have proof of financial security at all times. So the system that the safety runs, it runs it corruptly, but let's just assume for the purpose of this interview that safety is doing its job per statute. Safety has control of insurance for cause when there's the accident. Revenue runs on top of it as against the grain of the original purpose with this everybody is guilty perspective. It is a moral judgment that it operates upon everybody. All registrants are by definition irresponsible and unsafe, and they're all illiquid. So we have to force them to have insurance. Now, they keep denying in my case, which has been going on for a whole year now, that we are a financial responsibility state. And they say that because, they say we're not a mandatory insurance state because you have options. Well, the options are entirely bogus. There are two other options. One is that you could send the commissioner of revenue a check for $65,000 or buy a surety bond for your personal car or motor vehicle uninsured pre-crash. I could not find such a bond. And not being wealthy, I don't have $65,000 I can tie up with the Commissioner of Revenue
So what's the answer? What's the answer? What should they do?
Well, the answer is that we are effectively a mandatory insurance state because no one can do that except one person according to the deponent, one person paid $130,000 to have two VINs under this bond. The problem is the statute doesn't allow for the Commissioner of Revenue to collect that bond, and I've already invoked the authority of the Comptroller of the Treasury to look into this as a crime, because there's no provision for bond for cash payments like that to be made to revenue. Only safety can do that, and the safety bond. Remember what I was saying a moment ago. In a qualifying crash, the Commissioner of Safety will receive your payment. $20,000 crash, you send him that check for $20,000. That becomes the bond that he pays down the costs with. And it goes down, and if there's a balance left at the end, you get that back. The statute allows for the Commissioner of Safety to receive this bond to the level of the accident, and no more, but not revenue. So there are numerous breaches of law in my analysis of this statute with the gnomes, Christopher Sapp and Ed Sella. We found about 27 abrogated laws. Got time for another picture?
Absolutely.
Okay, so here. Let me get back this away. Okay, this is something of the same picture, but notice here you have all travelers, and there's a funnel that takes you into this system. Right, this is the financial responsibility pipeline, and you get there by having a qualifying crash, right? And you get into that pipeline through the combination lock to get into that door is the statute number. That's 5512-104. So you get into the door. DOS means Department of Safety. Okay, so what happens now is you get a hearing. Hearing. Now, in the current case that I'm highlighting with our fraudulent Commissioner of Revenue, there's no hearing. My tag was revoked after 4 notices without a hearing. And that that's a due process violation. So the law says, okay, there's a hearing, but after the crash, but you're violating the law. You get that hearing here. And now safety, DOSHS, notice to DOR to revoke tag. The Revenue Department is entirely dependent on orders from safety in this state. Safety, which oversees the statute, says, okay, Revenue, this guy has failed to make good on a judgment. He's violated the statute. He filed late, so we want you to suspend his tag. So that's done by DOR. Revenue has the tag. The tag is drawn out. So now the man who wants to have his car registered as a motor vehicle is in a real pickle. Of course, he knows he's going to get arrested if the tag is revoked. His license is revoked, so he makes for terms. Okay, now the terms are, in your state and mine, okay, well, I need my license back. Okay, you get your tag back, bro, but here's what we require. You've done so badly. We need to have your car under insurance for 5 years, 3 years, 4 years. The statute used to say 3 to 5 years. Now the statute's been updated to say for the duration of the suspension. But the suspension term could be 5 years. So you have to have, Gary, insurance in Tennessee for that length of time because you're a bad boy. You have shown yourself responsible. You've got to have insurance. So that's how the system is supposed to work. And now notice the pipeline here. You got this EVIS, right? EVIS, the Eye of Sauron. Well, this surveillance system on this narrow group of people in this pipeline goes on for up to 3 to 5 years. SR22. I think SR22 may be a global standard in the insurance industry, but you're in this chain here in this pipeline for this time.
Wow. And
EVIS is going to make sure that you have insurance at all times. That is your condition. You have your license back on condition. You have your tag back on condition that you're in the pipeline. You're under the Eye of Sauron, and you have to have insurance. So insurance is what people have to have when they're bad. And if you're rich, have insurance. But if you're poor, like me, I don't have insurance because I'm poor. So people like us, we don't have to have it. I mean, we're just taking the risk. think about this, Gary. Let me ask you a question. Do you think that if you don't have insurance, you're going to be a safer traveler, locomotor, mover, or driver, or less safe? Which one?
Well, I can't speak for everyone, but it would seem to me you would want to be more careful, not only for that reason, but your duty to your fellow man is not to harm or injure him. So that's why responsible people get these things. But it sounds that the state of Tennessee is just putting one more level of enslavement and surveillance, sliding it right in over everyone. What? Is there any other states doing the same type of thing, or are they kicking off the model?
This is a question for the listener. The listener needs to look into his own state. But again, the motor vehicle law in Tennessee is highly complex. There are about 48 provisions in the main body. The amendment, the Atwood Amendment, has only 15. But the thing to look at is this issue right here. How did these people on this date suddenly become liable? And what's really interesting, Gary, is that the Atwood Amendment, with the 15 provisions that took effect in 17, has in 214 it has a provision that this law does not change the qualification, the requirements. The requirements for financial responsibility are in no way changed by this law. So how is it that the state of Tennessee can, on this one day at 12:01 a.m., make all the people in the state subject when previously just these few were? How is it that an amendment to the law, simply creating a surveillance system, how does that create liability on you, where you shall do something?
I'm sure that they'll say that it's an anti-discrimination clause, right?
Well, I'm not sure, but after we had our deposition, we asked the lawyers about what about 214, and they said, well, we don't count that. The word for that is called pretormission. You pretermit. When a judge refuses to see something or refuses to count the evidence, he will say, well, we pretermit that. We don't see that. In other words, we decide, using our vaunted discretion, we decide that we're not going to see your evidence, or we're not going to see the facts. In my case, there's one fact, one dispositive fact, one fact that disposes of the case, and that is no qualifying crash. If there's no qualifying crash, how can there be liability? And the statute has numerous examples where certain people shall do certain things. That's called a liability language. And the hearing officer in this case, whom I know is going to rule against me, this is almost hilarious. He said, well, in one provision that directs revenue to issue notices, the word shall, the department shall do this. He believes that the word shall in a kind of administrative provision that describes how the notices go out, what they're supposed to contain, and so on, that since revenue shall send these notices out, that must mean that I shall receive them because they're liable to be sent to me and due to me, and that somehow through this distended process, the member of the public, meaning David Tulis or you, are liable. How is it that a statute that gives a duty to an agency can make a member of the public liable? It can't. One of the key rules, I think, worth considering and worth noting in your review of the law as a legal-minded person caring about liberty is the doctrine of adjustum generis, and that's that you can find that in the book, Gary. You said is available by former late Justice Scalia, right?
Right. Yes, we reference that often.
Okay, so the listener knows what that is about, but amendments in laws, for example, that have general statements such as this provision shall apply to every registered motor vehicle, that appearing later in an amendment to an already well-structured law cannot be understood to be suddenly applying a narrow-focused statute upon the general public, i.e. 100% of the registered owners. No, if that's going to happen, the entire statute has to be rewritten. So amendments to law. But what has happened in Tennessee is that legislators are working shortcuts. They don't want to do the heavy lifting and the great tedium of deleting the old law, thinking that they can just add things without doing the work of eliminating the old statutes. And the reason you can't rely, or that courts can't rely on preemption, the new law preempts this provision over here, is that may cause confusion. That may also create vagueness. So if there is a law that adds a new power, there have to be concomitant or consequential deletions elsewhere that do not allow for confusion or do not allow for double standards or multiple modes of enforcement. And the legislator in '99 who wanted to just tack on a 3-page amendment to say all registrants have to have insurance cannot have done anybody any favors had that passed, because you would have three standards of operation of this statute. You can't have a statute where the morality poses qualifying accident and proofs of insurance among non-insured parties potentially, and then have a separate statute that says all parties have to be insured. For example, if everybody has to be insured, why would anybody with a high risk insurance policy or SR22, why would that person worry about a 5-year term or a 3-year term to have insurance? You can't have laws that have 100% are liable, and then you have all kinds of exceptions that are not removed from the statute. So in the case of the risky person who has a judgment against her or him being under suspension, let's say for 3 years, you have to have insurance. How can that person on the first day after that 3-year period ends not say, okay, I can drop my policy now and get my refund from the insurance company because I don't have to have insurance? You can't have laws that are effectively nullified or abrogated or deleted by amendments, and certainly not by policy. So we have in Tennessee a rogue program running on top of the existing statute and touching it really almost not at all. And there are many, we've counted about 28 abrogations of the existing statute where language is simply nullified and cannot be said, I allege, cannot be said by the hearing officer to be abrogated by implication on account of his policy.
So do you think, I mean, obviously it's probably nefarious here, but is it a power grab? Is it a money grab? What do you think the motivating factor is here? I mean, it can't be just laziness.
Well, the motivating factor is complicity with our elites, our for-profit elites. The insurance industry pulls in about $3 billion a year in motor vehicle premiums, and I'm guessing graciously that probably half, let's say $1 billion in premiums, are free business for the insurance industry, and that would be from people who can afford insurance and who are glad to have it, glad to do business with these companies. But probably a lot of it is, coerced. I had an interview with a woman who was pulled to the side of the road with her Christmas money in her on her card, and she was forced to buy insurance, or her car and her child would have been left on the side of the road. The cop said, "Look, you can buy insurance right now. In fact, you can go to this particular company and buy insurance right now and get it right now. And you can, while I'm waiting, verify insurance on your phone."
So now we
with
have
those Q blocks.
We have the terrorist police agents, revenue agents, working for the insurance company now.
Well, effectively, yeah, he gave some insurance company that could show the puzzle block on the screen, and he could somehow verify that with his phone or his data that yes, this woman with this VIN and this tag number has insurance. I mean, it was all so that's where her Christmas money went. It was like $140. That's what she had. It was It was in Rossville, Georgia, just south of Chattanooga.
Crunching
So
on the bones of the poor.
That's right. These are the working poor. And Ed Solo, my gnome, who knows this law inside and out, was left on the side of the road in the Alcoa area of Tennessee near Knoxville with his wife and daughter, their minivan towed out from under them because he didn't have a tag. Why? Because he doesn't have insurance. And so this is a rape and pillage of the public. And I realize that the hearing officer is not going to heed me. He's going to gazoozle his way to accommodate all these blind spots that he has to take all these blind spots from the commissioner.
Well, the other thing is, this statute that allows the state to tow the car violates the Fourth Amendment. You can't just take someone's car because some officer has decided that's how it is. Where's the due process?
Well, that's right. There's also in the Tennessee provision, in the Tennessee law, a provision that there has to be a local ordinance for the corporation to do that in the first place. And it's very possible that some of these jurisdictions don't have that ordinance passed, even though this law, the Atwood Amendment, the EVIS project, has been going on for 7 years now. The corruption is actually worse. It goes back to 2002, but I don't have the Department of Safety in scope right now. I can't really address its fraud, but it's pretending also through a revision in the first part of the statute, in the original financial responsibility law in Part 1, that there is created this duty. But that claim violates the ejusdem generis rule, and is also illegal. And it's funny, the revenue's relying on an AG opinion that misinterprets that update of the law in 2002. It's a bogus analysis that overlooks one sentence in the AG's opinion that limits the scope of the opinion to just a narrow part of safety's enforcement. So we have misreading of AG opinions, and we have effectively a state agency in Tennessee relying on an opinion and a broad statement in the earlier statute, pretending to make the whole statute apply to all people, right, and not just to accident parties. So this fraud has been going on as a structural strip mining of the people since 2002, Gary.
That's pretty incredible. And just for reference for people that aren't paying attention or haven't been here before, ejusdem generis is a rule of statutory construction that gives you guidelines on how you are to interpret a statute, right? And so when you have lists of people, for instance, or lists of things, they have to all be similar, right? And so when they throw in something that, like an airplane with a mouse, a cat, and a dog, then you can't have an airplane with a list of a cat and a mouse and a dog, because they're not like things. So I hope I explained that as well as you would have. But yes, continue.
Well, I think to have these pictures in mind are important. And so your job, if you have a friend, I know you're always helping your friend, but here's an area. This is a means of resistance. This law in your state may well be a means of resistance. Now, I want you to know this. Keep track of your time like I do. I track everything I do. I have a special notebook, and I'm suing in agency, of course, and I'm in persona propria as a man on the land, as I like to say. I'm not pro se. And, they don't really care about stuff like that, but I make sure to have the proper language. And I will be billing. I'll probably have to sue for it, but I'll bill my time. I make, and in your record, it has to be done contemporaneously. You block off 15 minutes, work down to the 15-minute tick on your clock, and make note of what you're doing, like revising brief or checking the statute. If you're spending an hour reading a case and marking it up, mark that case down as read this case. looked at 139 or, did Westlaw review or what have you. Make note of it
Mm-hmm.
because the judge he's going to hold you to a high standard. He's going to know exactly what you did in that 15-minute period, and keep it going. And if it goes on for a long time, you'll want to start putting this in a file in your computer, okay, on your drive or on your Google Doc, timesheet. This is my van timesheet. My van is involved in 2 court cases, by the way, and very, very controversial car. It's involved in my a lawsuit I filed just today in federal court against vampire lenders. So it figures in that case because there's a judgment of execution against this car, and it's also involved in this case. But keep a record of your time.
Yeah.
Always keep a detailed record of your time.
I'm bad about that.
That, Gary, tut, because if you show your time, you can bill them for it. And I'm going to bill $300 an hour. I mean, why not? I mean, maybe 400. And if they want to, Jew me down to 250, well, that's fine. I mean, that's more than what I'm earning, being unemployed journalist, right?
Right, sure. And so you're right that we keeping track of the time at the end of the day. I mean, when you get attorney's fees, even if you don't even get a judgment, you get attorney's fees, then you're going to have to show what you've done, and you can't just come up with a number out of the sky.
So again, in this picture, EVAs, what they're doing is they're using the eyeball, the surveillance eyeball that you have it in your state too. Your state has the same thing. They're using the surveillance eyeball to impose, I'm just proposing this, mandatory insurance in your state. Your state may simply be a financial responsibility state. So if that's the name of your statute, start with the name. And very likely the name will tell the truth about how it's supposed to run. And if they've gotten it away with this for all these years with 18,000 lawyers in my state, and no one's brought this up, well, you may be delivering tens of thousands of people after you're gone from misery, oppression, loss, hurt. And so the people who can't pay insurance are the poor. And we say, well, some Hispanic guy ran into the back of me, some young Hispanic punk ran into the back of me. Well, maybe young people are bad about that, but generally people who are without insurance know that, and if they're foreigners, they generally don't want to deal with police. If you're an immigrant, you've come into this country, you hate police, you hate narcos, you hate police, you don't want to have anything to do with them. So you're very careful. There are always the exceptions. And so people who don't have insurance like me, I'm very, very conservative, behind the wheel. I'm very cautious. I don't run orange lights. I'm always at the speed limit or just under. So, and poor people are the ones that they get, and they are the ones whose tags are revoked. And the eyeball is supposed to look on the bad people, not the poor people, the bad people.
Right. Yeah. What a shame. What a shame. I can tell you. Can you elaborate a little more on what do you do in the press, or what you said you're reporting on court stories, right? And if that's the case, we have a lot of interesting stories for you, but just give us a little brief history on that.
Well, I'm again, my name is David Tulis, and I was 24 years as a copy editor at the local newspaper, the Times Free Press, now owned by Waco Media, which is out of Little Rock. And a copy editor is the editor who writes the headlines. He edits the stories for clarity, accuracy, and then he designs the pages. Or now that we don't have pages anymore, he puts it up on the internet. I was in the print business, so I was doing that, and then I went into radio, where I've been for 12 years, investigating and giving officials a hard time. And I have several cases that are of interest. One case is about Social Security numbers, and my case, Tulis versus Green in Tennessee, forced the General Assembly to rewrite the motor vehicle application statute on SSNs. And thanks to my case, the General Assembly rewrote a perfectly clear statute that I was trying to uphold in my suit. And they said, if you don't have an SSN in Tennessee, all you have to do is swear out an affidavit, Gary, that you have never been issued one, and we will give you a driver's license. Because I was suing to get a driver's license renewal without the SSN, since I had affected by the equitable remedy of rescission of contract, the signature of my parents who had applied to get me into the machine. And I deemed that was constructive fraud. So I took all the proper steps to rescind their signatures and so on. And so I did not appeal a negative ruling out of the Court of Appeals in Nashville. It went up through the admin courts into Chancery in Nashville, Davidson County, and then to the Court of Appeals. And by using legal trickery, the Court of Appeals ruled against me. And so I was just exhausted from my efforts, and I did not appeal it. But the General Assembly rewrote the law to account for everything I had to say. And I would say, if you're someone who has rescinded your SSN application signature, and you're in Tennessee, and you've done that without, with acquiescence by the other side, you can truthfully say in an affidavit that I've never been issued an SSN, because rescission goes back to the beginning of the process, ab initio, really since the point before it began, and undoes the application, the signature, and everything. And so it's not dishonest to say under that remedy that you in fact don't have one. You've never been issued a number because it was not a lawful issuance of the number, because it was not a lawful application for the account and the benefits and so on.
So you normally, yourself don't apply for the SSN. It's usually your parents or something like that. How do you rescind someone else's signature?
Well, if it's for my benefit, on my behalf, when I become of age and become aware that I'm being defrauded, I'm required under the rules of equity to not sit on my rights, not sit on my hands. And so when I determined that I had been defrauded, I acted post haste to rescind and to make sure that everybody who might have some interest in my name and my account got notice of this allegation of constructive fraud. And then in that meantime, my license came up for renewal. So I changed my answer on my certificate of renewal that the change was no SSN.
And that's what you get the legislature to say they had to be able to issue a license whether you had a Social Security number or not, right? And you got that change?
That was I had nothing to do with the change legislatively. That was done by Department of Safety, evidently concerned about its statute going up in smoke from my case. And so the Gotcha. DOS, Department of Safety, petitioned to have the statute updated to account for what I had to say. So by God's providence, you could say I lost while I won.
Yeah, well, that they always find a way to snipe you on the way out, But good on you for taking up the cause of what they're doing to the poor. I mean, it's the lending. I think you have a lending lawsuit too. You filed today or something like that.
Yes, I did. Thanks for asking. I filed a complaint in federal court against vampire lenders. Now, if you're in business, you've probably dealt with these people. No doubt you get come-ons all the time. Since I've done so much research on these gangsters, I get ads for Capitus and other Advantage and other MCA lenders continually on YouTube and elsewhere. But do you have a minute? I can explain what to look for there. I mean, this is important to see how these people states laws. Many states have usury laws that have an origin in Christianity and in the medieval period, where lending is considered a vice, and limits are placed on the amount of interest, the per annum rate. And the parties I'm suing violate the usury law in Tennessee. And there are three lenders that I'm targeting in my case, and two law firms. One of them a notorious law firm called Cheadle out of Nashville. But the gag is this: you are in business. Let's say you're running a factory, and you got a chance to buy some equipment, updating your production line. Okay, so let's say it's $500,000. You've got a short time to get this money to buy this, and real lenders, take too long. And you don't think you have enough time, and you don't have enough really valuable real estate or property put up for collateral from a bank loan. So you go to these shysters who are there, and they can get you $100,000 in they can get you $500,000 in a day.
Mm-hmm.
Well, the terms are this: we're not lending you money. Okay, we're going to share the risk with you. We're going to do something called revenue-based revenue-based capitalism. You have a revenue stream, right? Right. That is to say, you run a factory, you have wholesale customers. We'll lend you the money to buy this equipment. You can install that and start production with that in the time of our terms. And what we're going to do is we're going to buy your receipts. We're going to buy your receipts, and you agree to give us access to your account. We'll agree that we'll take 10% of receipts. So every day you get receipts coming in from your wholesalers, your customers. We'll monetize that, and we'll regularize that. Okay, we'll regularize it. So in the radio station business, we had one receipts purchase, pretendedly. I forgot the numbers now, but let's say $126 a day. So that's 10% of my receipts every day, supposedly. And so it's pretended to be a sale, risk sharing market risk. Lenders have financial risk that they bear. There is some financial risk in lending. These people say, well, we're not lending you. No, we're not. This is not a loan. This is not a debt. This is a purchase. And we're purchasing your receivables. Now, the contract has at the end of it what's called a personal guarantee. And the personal guarantee is usually the owners of the small enterprise personally guaranteeing the whole amount.
Right.
On a trigger system. If you default under any of our 10 or 15 triggers, we can demand the whole at once. We're going to call the loan. So the guarantees at the end of these contracts are that which sort of overwrite the pretended purchase agreement and convert the purchase agreement into an actual loan. If it's a loan, then the rate of interest becomes of special note to the court, and that is it above 10%? And so the parties I'm suing, one of them had an interest rate of 208%, and the second party had an interest rate of 593%.
Wow.
And yes, wow. And so these are short repayment schedules, like half a year, and they take it out every day. And of course, these loans were granted just at the beginning of the collapse in 2020. So I could not meet any obligations in my business. And they were unwilling to wait. They were unwilling for us to have receipts, to buy, right? If they're buyers of receipts, then you have to wait for supply to get back in, right? You could say, Garrett, I was having supply chain issues on receipts.
Right. And so they're not a bank, so they're not monetizing that debt, or how's that work?
Well, they extend credit. I mean, they're extending money. Money did hit our account. So it came from somewhere, but it's not a loan. They say these are just an advance on your receivables. It's called an advance purchase of future receivables. That's lawful in Tennessee to have that. It's it's a paper. It's kind of an economic paper transaction, lawful, but the guarantee makes it a loan, and the operation of this collections all indicate loan type arrangement. And a lot of these lenders are in New York, and the people who bought the bad debt from the Lendini, which is one of my defendants, it's seeking to enforce an obligation that is a criminal act in my state. So I'm suing them for my time. I'm suing them for damages in being sued. One of them, Flexibility Capital, won a judgment against me in our courts, in our wicked and prejudiced courts that don't recognize when it is that a case doesn't have subject matter jurisdiction. You can't, if you come into court with dirty hands trying to enforce an agreement that is a violation of the statute, you don't have standing, and you can't get the court's attention, and the court doesn't have subject matter jurisdiction. But Tennessee says you can do that. You can't have no standing, no jurisdiction, but we're still we're gonna rule against Tulis and his radio station.
And you're gonna fix that, right?
Well, by God's grace, I'm suing them for injunctive relief, for damages and injunctive relief, including 2 years no business in Tennessee, and an order of injunction lets you serve parties in like standing. So if I get an injunctive order against these three predators, I can serve it on other such businesses who do business in Tennessee.
Right.
And they have to stop. They cannot do business in Tennessee. Right. So that's my public interest part of my case.
Okay. And so before we go any further, would you tell people that want to contact you how to get in touch with you if you want to do that at all?
Oh, sure. My phone number is it's a 423 area code, and it's 316-2680. That's 316-2680, and that's 423 the Chattanooga Exchange. And I'm a blogger on Substack, and probably the best place is David Tulis. That's with one L, David Tulis, TULIS. .substack.com, and I have a long history in writing, and there's a separate blog. It's a WordPress blog that's been going for about 13 years, and it covers traffic extensively, and it's called tntrafficticket.us. So that's TN for Tennessee, TN trafficticket.us. And we've just thoroughly gone through the motor vehicle code and the carrier code, and the short of it is that states everywhere, all of them, join in a fraud upon the people. Their own people are defrauded, and hundreds of thousands of criminal cases are generated by what I call, Gary, I call it commercial government. This is a phrase that Tupper Saucy used in his Miracle on Main Street book back in the 1980s. But when government becomes commerce and feeds in commerce and feeds off of commerce and generates its own self-important machinery and lubricates its machinery with the victims, crime victims, it's commercial government. And that would be the judicial industrial complex with police and courts that need to have cases. Now, I've got a case going against one of our Supreme Court justices. It's on appeal right now in Cincinnati in the Sixth Circuit, and I have in play there an injunction to compel compliance with our arrest law. Tennessee, like many other states, is a red coat warrants state, and the injunction I claim, if it passes against the city of Franklin, Tennessee, which is right next to Nashville,
right,
which I'm suing, if it passes, Franklin, Tennessee cops will have to cut arrests by 30% to 60%. So this will put a big dent in Jim Crow operations here in the South.
I like that.
I'm sorry?
I like that. That is very clever. I enjoyed hearing that.
Well, yeah, these are red coat warrants, and every state violates the prohibition on warrantless arrest, every single one, including Tennessee. So what I've done is I've read the statute, and the key point about Tennessee violation of the statute in every jurisdiction is that, and the citation is TCA 47103, 47103. That law says that a warrantless arrest can be done on two tests, and cops always do just one test. The second test is the one that really matters. And the test they meet in a warrantless arrest is in the officer's presence. The other test, more significantly, is called the public offense test. And when I was arrested for covering the judicial conference in Nashville area, it was a breach of that law. And I had to have been arrested under a warrant because, attending with my bow tie a judicial conference and sitting at a conference table is not a public offense. It may be an offense, but it's not a public offense. So they had to get a warrant. And it was in a room full of judges. Any one of them had authority in our law to issue an arrest warrant, to draft the warrant and issue it and sign it on oath of the officer. But that wasn't done. And so that is a major breach. And I think every state has the public offense standard that is in play here. It's in play in that case. And by God's grace, there will be relief. And if we can cut arrests by requiring the clunky, long, befoggling problem of having to get an arrest warrant and then finding the person, that will cut arrests back big time. I mean, now a cop can make 7 arrests in a day or more.
Right.
But it could be that if a warrant's required for a misdemeanor, because it's not a public offense, has to have a warrant for it, it might take him 2 days of research, investigation to make 1 arrest. So that's the Constitution says arrest is a big deal.
Yeah, it should.
And you can't just arrest somebody just because he's in front of you. You have to let it go, right? Make your investigation as much as he'll let you. Let that person go. Get the warrant. Then you have to find the guy. Good grief, you've got to find someone? My goodness. They've been just arresting people on the spot for decades, for probably 30 years here in Tennessee.
Sure.
I read the law, used my noggin, just read the cases. What is a public offense?
Right. And
you want me to tell you what a public offense is in a nutshell?
I was about to ask you. Yeah.
Yeah. Okay. The public offense standard in Tennessee is very like probably what's in your state. And a public offense is in the nature of an affray, a riot, a disturbance of the peace. In fact, the statute here says in the 2-part test, in the officer's presence, or a public offense or a threatened breach of the peace. So a public offense is a breach of the peace. So a public offense is not driving on a tag suspended, right? Driving with a headlight out, driving with a tag light out, not using an indicator. Those are not public offenses. A public offense has a face. It is visible to the eyeball, and it has a ripple. A man standing on a corner of a neighborhood intersection, let's say, swinging a chair or a bat, bellowing, cursing, drunk, threatening people in passing cars. Is that a public offense?
Sounds like it could qualify.
It qualifies because it ripples out. People get scared, right? It's something you can see with your eyeball. And it affects other people. It makes them feel for their safety, for their welfare. A public offense has to have a cause. It creates a cause of alarm in the member of the public. It's not a crime.
And wouldn't
it's a public what?
And wouldn't they need a member of the public to sign a written complaint in order for this to happen?
No. You don't have to have a warrant, right? It's arrestable without a warrant because it's a public offense. And if the officer's there to see it, right, it meets the 2 tests in Tennessee. So public offense is not arrest. If it's not a public offense, it's not arrestable in Tennessee. No traffic case is arrestable in Tennessee without a warrant. That means that traffic stops, which I'm trying to stop as a state function statewide, it has to be about litigation. Being in the press and talking about it does nothing. Okay, I've talked about this for at least 6 years in Tennessee, Chattanooga area. No effect. No one pays any attention.
Right.
So a proper petition with a proper argument, with proper facts, will bring relief. The law can be made to work. And they may escape, one case, but they can't escape another one. I mean, if you properly raise the issue,
Right.
You will get relief. The law is very conservative. And the problem is no one's brought these issues up. People do not understand the law. And that's what I hope your group will help with, Gary, in Tennessee and all the other states. People need to know that the law does matter and it does work. We just have to make a proper petition. If you ask the wrong question of a judge, what'll happen?
Depends.
You'll get the right, what's that?
It depends on the judge.
No, well, the answer is you'll get the right answer to the wrong question. So you have to ask the right question. You have to defeat presumptions.
Yeah.
Presumptions control in most cases. And I'm willing to bet in your state and in mine, probably 98% of criminal cases are defective.
Oh, I guarantee it. Guarantee.
Yeah.
Guarantee. Do you know John Gentry? Do you know that guy?
Yes, I do know John Gentry. Highly, highly respect John Gentry, a candidate for governor, running now for state senate. He is the judicial reformer.
Yeah.
In Tennessee. No one should vote for anybody but John Gentry if they take part in the franchise.
Right. Yeah. I figured y'all knew each other. Y'all both in the same area and now in same realm with all the law stuff too. So.
Yeah, I've interviewed John many times. He's a regular source of information, a kind of fount of wisdom, and the idea of remonstrance and petition is extremely powerful. And I think we, as our country has this catharsis in the coming year, the idea of redress of grievances and remonstrance will take effect. Lawsuits are just remonstrance to the judicial branch. If you have a remonstrance to your General Assembly, it's the same thing. It's kind of a lawsuit upon the General Assembly's ears. This is a problem. You need to fix it. And I plan to do remonstrance to the General Assembly on some of the issues that I've reported on.
Yeah, nice. I like to see that. We had John on a couple weeks ago, and he was telling us all about it. So hopefully that's something we can implement. And would you tell us a little bit? You said you have a little group together. You call them the Gnomes. How do y'all organize your stuff and work together? And then let me invite y'all to collaborate with us for sure, because we're in almost all 50 states at this point.
Well, I call these men the Gnomes. One of our leading members is a man named John Ballinger, a carpenter who's got bad knees. He's in a kind of nursing home right now, but he's always working cases, and he's a man outside the system, a highly principled Christian man. And his name is Ballinger, and he and I have gone back. We've talked for many conversations on my cases, his cases. Others are men. They're very common people. One is a kind of a chain smoking man who lives in Section 8 housing, and Ed Solo, remarkable figure, learned in the law, kind of a genius. He knows the TFRL, the Tennessee Financial Responsibility Law, back and forth. And he's the one, he'd contacted me about his situation. When my time came to, I was mentioning John Gentry, but also just wanted to mention that the Gnomes are very common people. Mm-hmm. And one of the Gnomes, he's not my gnome, but one of the Gnomes is just a remarkable man named Christopher Sapp. He's my mid-state bureau chief. And his line is computer repair. He is a natural genius. He's an absolute bulldog. And we've reported on, he's gone down on some of the people we cover and just absolutely bulldog the people whom our story subject is dealing with. So he's like counsel, journalist, inquisitor, and very hard-hitting man, very colorful. Very common man, very common background, reads law all the time. We listen to court cases on YouTube from our state, which I hope is something that your listeners do in their spare time. Just listening to court cases. In a court case at the Supreme Court or Court of Appeals, you have the best of each side on an issue, the distillation of all the facts, all the the legal arguments, all the law, distilled down orally while you're in your car traveling, right?
Right.
Or locomoting, and you're hearing a debate over a controversy. Very important thing to do.
Yes, absolutely. And we need to definitely collaborate. We could use more geniuses. I can tell you that.
Well, I'm humbled to have very common people. Another one of my gnomes is a Tennessee man who went to Texas to get a driver's license under a mandamus, and then he got sick there. So we're dealing with him. Deep insight into how the law works. I think my other friend Levi is a George Gordon Barrister's Inn graduate from many years ago, and he has a natural inclination to God's law generally, and men's law specifically. And we are continually discussing our problems, and commiserating and so on. And so it's good to have friends. It's good that that you, Gary, and your Telegram listener, thank you for joining me, are working together.
Yeah, absolutely. And you have the links now, so any of those guys that want to jump in and check out what we're about, and even if they just want to participate in the Tennessee chat or whatever, it's we would love to have them, and I think they would find a lot of useful information, and like minds to bounce things off of.
Right. Just talking with someone about your problems is very helpful, and that's what phones are. In the time we've been talking, Gary, I've had 2 calls from Ed Solo, just trying to get through on some point he's made. He sent me a document to look at. So we're looking over each other's shoulders. We're sharing files.
Right.
And sometimes I draft documents for people, and we've had remarkable success here on certain things. I've got cases. I think what I realized is that I'm not going to get hired anywhere. I've applied. I'm looking for work, and law offices won't hire me. I've gone bottom of the barrel law offices, and they find somebody better. And high end offices, I'm a controversial figure. I'm kind of, maybe you might say, notorious.
Right.
And I've said many evil things about lawyers, and so maybe no one will hire me. But there's one law firm that I've really pushed to get into. That's because he deals with. I think he respects me, and he's not afraid of me, and I think I can really help him with some unusual legal analyses. And he deals with very poor people, so that's the kind of people I want to help. And I don't have a law license. I don't give law advice, legal advice. I don't have a law business. I've been threatened with UPL by the DA, by 2 judges. One judge threatened me in open court with UPL as a next friend. So I've had to deal with very harsh circumstances to help people. And I when I told the judge, I said, well, Your Honor, you got 3 ADAs here, and I'm speaking on behalf with this woman and sort of in her regard. If they want to get an indictment for her, go ahead, get an indictment. I mean, UPL requires that you have a practice, that you have a business, that you solicit, that you take payment for the good things you do. If you're doing these things as a Christian mercy, I should be adopted by a church, not threatened by a judge. My work is one I'm asking churches, adopt what I'm doing as a Christian mercy fighting ministry. Right?
Yeah, that would be wonderful. So we're helping our friend Kurt right now. He was falsely arrested over in Seattle because he had a case way back when he wouldn't wear a mask in the grocery store for the pandemic, and a couple other things. I mean, it is snowballed into. I just talked to him on the phone. There's 12 cases that he's brought against judges and all these things that are all involved in all of this, and that he needs me to stay because they won't give him pen and paper in the prison. And so he can't defend himself or anything like that. So we have a team of people. We started a special group, and we're just what he needs to write and what he needs to do. And we're going to, I think we're going to get him out. So we'll see. But that type of help is what we're all about.
Well, Lord willing, there will be relief there. But I would just suggest that if you're serious about doing your own case, and always do your own cases, learning from your mistakes, keep a record, keep a contemporaneous record of your time, because the time that if you're in a criminal matter and you're at some point cleared, the damages are not just the jail, the
Right,
handcuffs, the hearings. It's all your time in preparation. So have
right.
distinct entries for each case. You may, if you get really bad, or maybe I should say good, you'll have 4 or 5 or 6 going all at once.
Yeah, yeah, yeah.
Just have distinct entries and make note of what you do. That's how you get reimbursement. And that's how you establish the standing of your injury. Your injury is the time commitment that you made. So please keep the time accurately with details. That
that
when
is.
you're suing, you have to show standing. And standing is injuries, specific harm to you.
Yeah, that's sage advice for sure, and that is something I'm going to have to start implementing for sure. But I want to be respectful of your time. You scheduled us for an hour. We're at an hour and a half, and we took a lot of time with technical difficulties. So, if you have something else you want to go to, that's fine. But if you want to wrap it up, I'll give you the last word.
Well, the last word would be this. I suggest you consider the tactic that I've used successfully, I think, here. And I can't say it's been used successfully because the judges dodged the filing. The filing was this. The criminal case against me in a traffic violation was improper because it was premature. I filed in my case a pre-plea remedy and avoidance, stating that the case should be heard administratively under the UAPA, Uniform Administrative Procedures Act, in my state's Department of Safety, right? Your DMV. It's an administrative matter to have a tag license out. And it was not established that I was on my license. I was arrested for tag and failure to exhibit license on demand. The tag and the license are both under the Motor Vehicle Code, which has UAPA connection. It's premature for you to be criminally charged. It is civil matter, administrative matter under your license. It has to be heard in agency in a contested case administratively in your state capital or in a branch office of your DMV or your Department of Safety. And the prosecutor didn't want to deal with this issue, so she dismissed the case. So I can't say that it won, but I can say it was mystifying enough, or maybe complex enough, that they said this case is not worth the trouble. We're not going to even read it. Okay, so maybe that's what happened, but
Right.
it is at least very plausible. And I suggest it's not just a plausible remedy to scare off an overworked DA. I suggest it may have some merit, Gary.
Right, right. And so, last question: how do you think the new Chevron decision would affect that?
In the insurance scam, we are dealing with something way beyond the Chevron deference. My state has a road program completely outside the statute and contradicting to the statute. So, Chevron deference is all sort of believably in the scope of authority of an agency, a federal agency. But these agencies can't fill in the gaps too much, and they can't have extensions of power in a gap that goes beyond what other parts of the statute would suggest are not plausible or possible within the scope. So the Supreme Court is saying these issues that are in the gaps have to be judicially handled and cannot be cannot be created ex nihilo in the agency to fill in. So Chevron is very important for us, very important, and we should all read that case, celebrate that case, and very important. I'm glad you brought it up. Thank you.
Yeah, but now I'm sure we could talk for at least 2 more hours, but I'm gonna respect your time for now, and before we get into another 30-40 minute conversation. But thank you for coming on. Don't hang up after this. I'm gonna talk to you for a minute, but thank you very much for your time. We appreciate it, and I think I learned some things about insurance today that I didn't know. And I know that many others will learn other things as well. So thank you for your time.
Well, Gary, it's a real honor. Thank you.
Likewise.